All right. So the defendant was convicted of fifth-degree felony, and this was a hearing for evidentiary hearing on the allegations that were filed on the 5th of April. Now, does your client wish to have hearing this earnest literacy admitting?
No, he's prepared to admit.
All right, Mr. Winters, the allegations allege that you violated Rule 7 in that honor. You were given a drug screen on April 4th while incarcerated Greenfield. Test positive for meth, amphetamine, buprenorphine, and fentanyl. And Rule 15 that you still owe $528.50 a clerk for court costs and made no payments. And Rule 19 that you failed to complete aftercare at work. So those are the allegations. You have a right to hearing, which the state have drawn evidence and proves to the court that you have violated these conditions. You have a right to have your attorney cross-examine those witnesses. Try to bring out evidence on the side of the case. You have a right to offer evidence and testimony on your behalf. But not required to do so. Use against you done. Now, in the event that you admit to these violations, like we want to treat that, continue commission control under the same condition originally ordered. Continue with additional conditions I think are appropriate. For the third and the most serious is like remote your commission control since you're in prison for between 6 to 12 months and fine $2,500. You understand that? Has anyone promised you anything? Excuse me, promised you anything, correction anything to get you within these violations? So you understand the consequences of these violations, right? And you admit to the violations? Right. All right, then the court will find that the defendant has admitted to the violations. Now, anything from the state or probation department regarding this position?
Yes, thank you, Your Honor. Given the results of the drug screening and conviction, jail, and court, clear there's an ongoing substance issue here. As such, the state has to continue on keeping control. In order to complete STAR, there is a better way to last STAR. Thank you.
Ms. Witt?
Yes, Your Honor. We also asked the court for an opportunity for him to continue to be jailed, but since he was successful in treatment for so long, we think that residential treatment and aftercare would be beneficial to him. He was clean for over a year. He just explained to me that he's had the death of 5 close family members, including his mother, and that led to his relapse. And he just did relapse one time. But we asked the court for him to be able to continue in residential since he was successful in that for so long. Thanks these unfortunate circumstances too that led to his relapse.
Winters, anything you'd like to say?
I think my attorney summed it up pretty well. That I applaud my family and I stay strong. And I got to be here. It's got too much for me in the last couple of months. I relapsed. And I would love the opportunity to go back to in-house treatment, learn what that means I have to do, and my aftercare. Love it on the opportunity to try to get it on time and try to learn how to deal with this right and practice.
All right. Well, it's a judgment over the court that you need to keep on committing control of these conditions. The court's going to extend your community control for an additional year. You complete the STAR program, you'll remain in jail until you go to STAR, which has been available before. And of course, going to refer you back to drug court. You originally restrained the drug court, and because you had done so well, the coordinator didn't feel that you were in need of it at that time, because you had done a self-referral. Believe it. I'm sorry for the situation that you've gone through, but honestly, I think you're probably lying to yourself about that. And there's some other things going on. People lose people all the time. Don't do drugs or do things crazy. So you obviously need to have some, I think, including this STAR, will be hopefully some mental health evaluation as well. I think once you come out of STAR and aftercare, hopefully you'll take a look at drug court and decide that's something you'd like to do. I think it would be beneficial to you, and you can get some more support and hopefully keep you so that'll be the order. Anything further, Council? All right, thank you. All right, Joseph Lee. All right, are you Joseph Lee? All right, I have two cases before the court involving Mr. Lee, 20 CR 97 and 19 CR 228. He was framed by Zoom from jail, was terminated and within framed by Zoom, also framed by Zoom, Assistant Prosecutor King. And this, I know we were in court previous on this, in court back and try to sort this thing out by, I think we did, and the probation department and congressional court has filed a corrected allegation on April 14th that alleges that he had violated Rule 13 in that on or after 4/1/22 you have a complete recommended counsel to free call to begin. And have signed by Officer Kelly on the 14th, and that is a correct allegation as far as what's being alleged. Now, Ms. Witt, you and your client both agree with this hearing to be conducted by Zoom rather than in person.
We do, Your Honor.
You're in agreement with that, Mr. Lee? All right. Now, does your client wish to have an hearing on this matter, or will be admitting to the allegation?
He will be admitting to not completing aftercare, however, obviously not to some of the specific underlying facts that are in the corroboration, but is admitting he did not complete aftercare.
The allegation is on or after 4/1/22 to get complete the recommended counsel to free to call or to begin. So he's admitting to that.
Yes, Your Honor.
Okay. Now, Mr. Lee, if you admit to these violations or if you're found to violate them through a hearing, I do one of three things. I continue good control of the same conditions previously ordered. I continue with additional conditions I think are appropriate, including extending their supervision up to 5 years. Third, and most serious, is I terminate you from new control and sentence you to prison. In case number 20 CR 97, failure of fear is a 4-3 felony, 16 to 18 months, and the 19 CR 228 is aggravated possession of methamphetamine 5-3 felony, which is 6 to 12 months, so that's possible for a term total of 30 months, fine $7,500. Now you understand that, Mr. Lee? You understand the allegations? And has anyone promised you anything to get you to admit these violations? Do you understand the consequences, potential consequences of your admission to these violations? All right, do you have any questions at all? And do you admit to the allegations that were filed as corrected in the April 14, 22 filing? All right. Anything from the state probation department regarding this position?
Thank you, Your Honor. It's a state position that this defendant is not able to be in control. This would be his third violation since being placed on the control. He's had numerous opportunities to treatment back in August. Please, Lord, in the next place where after crossing the second day of violation, he was again receiving on the where he was discharged based on all that state of action.
Ms. Whit?
Yes, Your Honor. Speaking with Mr. Lee, it's my understanding that he believed he was entering aftercare voluntarily, which he wanted to do. He did complete STAR successfully. I believe the discharge report from STAR is something to that would be beneficial for him to complete aftercare upon his discharge from STAR. However, since then, he has been in his aftercare working full time. He's gotten his license. He's been doing very well and has not failed any drug tests. The first actually will be clean a year on May 15th. So it wasn't due to any kind of drug usage or anything like that. But in fact, he has a difference of religious opinions from New Beginnings. He does want to continue his aftercare. He was being, what I understand, forced to attend a certain church to have certain beliefs, and it was just something that did not mix well with his personal belief system. But he does want to take aftercare. He has been clean and sober from what I know, and would like the chance to continue to finish that aftercare.
Well, my understanding is that he had been in Ed's place aftercare back in October of last year. Is that correct, Mr. Walter? When he left there? I can't hear you. You don't have your microphone on or something. I'm not getting any volume.
That's accurate. I have Officer Kelly's notes in front of me. Jesus.
All right. Well, and I also, my understanding then is also that Mr. Lee entered into this program voluntarily because it was his choice, because they're offered up different options, including the faith-based program. But the enforced policy, the base part policy is only forced to go to a faith-based program. They have the option to go to one if they choose. If they do, then they have to complete it. But my understanding is because he was given the opportunity to complete Ed's place, he left there, and then there was an option to give it up other programs, and he said he chose to go to this faith-based program. That's my understanding. Is that correct? Mr. Walsh shaking his head, yes. Okay. All right. Well, the problem here, Mr. Lee, I don't know. We don't have any allegations that you're using the drug, but the problem is that you keep coming back here to court, and we haven't done anything since you got out of STAR that you're supposed to do. You were at Ed's place, you left there. Then you chose this place and you left there. Well, actually, they kicked you out for reasons that they feel were correct, and we're not going to litigate that. But bottom line is, you're not doing what you're supposed to do, and this is the third violation that we have here, and it's just it seems you don't want to do anything that you're supposed to do. You want to just do whatever you can to stay out of prison, and that's not just correct action. So, court feels that you're not meaningful to control, that you've proven that you're not going to comply, and there are other things you put in charge as well, okay, the report previously before. But it's court's order that you're in control be revoked, and it should be sentenced in case number 19 CR 228. To a term of 8 months, and on a 29/7, be sentenced to a term of 9 months, consecutive to the 20 CR 97 base. Courts imposing second sentences because second case, 2097 committed while you're on community control in the case, and two or more separate course of conduct, and the harm caused by one is not adequately reflected in one single sentence in the sentence, are not disproportionate to the seriousness of the offense. Now, according to the jail, you have 56 days of jail time credit. How many days of started do you have? You have that, Mr. King?
See if I can find that.
You know how many days were started, Mr. Lee?
35 days, Your Honor.
How many?
105.
105 days, all right. Okay, so jail time credit will go on 19 CR 228, 56 days. Plus 135 days of STAR. That's 191 days of credit. Now, upon completion of the sentence, Mr. Lee, it is possible, alcohol authority will choose to put you in close control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer at the term they set. And during that period of time, they determine that you have failed to comply. They can return you to prison, you may serve the entire term set by the court for an additional period of up to 9 months for one or more violations. However, if you commit a felony, then an additional sentence the judge in the new case imposed upon you. That judge is also authorized to sentence you for failing or for committing that offense while under close control in this case for an additional period of 1 year, whatever time that on that period of close control, whichever is greater. If that occurs, that must be served secondly the sentence in the new case. All right, is there anything further from counsel?
There.
All right, you're remanded back to custody, Mr. Lee. All right, and let's see, Mr. McKenzie's here at court, but I think we have Mr. Powell, and that's not until 10. So we'll go ahead and recess, and you want to go to the courtroom, Mr. King, Mr. Wood, Mr.
Your Honor, what about Mr. Kramer?
Oh, I'm sorry, yeah, we do need Mr. Kramer, I'm sorry, yeah, Robert Kramer, yeah, go ahead, or Harold Kramer, go ahead. I was thinking he was not in custody, if that was All right, are you Harold J. Kramer?
Yes, Your Honor.
All right, this case number 21 CR 201, State of Ohio, versus Harold J. Kramer. Mr. Kramer is appearing by video at the Justice Center. His attorney is Danielle Witt. She is present here by Zoom. Also, Mr. King, the prosecutor, is the assistant prosecutor, appearing by Zoom. Ms. Witt, you and your client both agree to conduct this matter by Zoom rather than in person hearing.
We do, Your Honor.
You're in agreement with that, Mr. Kramer?
Yes, Your Honor.
All right, if at any time you need to talk to her about anything, just let me know, and I can push you to her into a breakout room, which would allow you and her to talk alone without anyone else being present, and else to see you or hear. Okay? All right. Now, the defendant is charged with breaking and entering and theft with 3 co-defendants. And I have a plea form here, Mr. Kramer, which indicates that you're going to withdraw your non-guilty plea and plead guilty to count 1. I'm going to hold this up to the screen. This is the camera, so you see your name and case number there. Plead guilty form. All right. And on page 3, there are signature lines. There's a sentence about a third of the way down that says enter the plea voluntarily. Immediately below that, there's a signature here to be Harold Kramer. I'll hold that up, and that's your signature there.
Yes, Your Honor.
All right, when did you sign this agreement, Mr. Kramer? Alright, and your attorney was there to, deal with you when you signed,
Yes, Your Honor.
and did she, go over with you and answer any questions and explain it fully to you before you signed it? And do you feel you had enough time to fully consider this matter for making this decision?
Yes, Your Honor.
And are you entering into the agreement to plead guilty voluntarily?
Yes.
Is this,
Your Honor.
is this still what you want to do?
Well, Your Honor, I'm hoping that we'll figure it out.
Well, the question, that goes to sentencing. The question is whether or not you're entering into this agreement voluntarily.
Yes, Your Honor.
Okay, you get the part for the course, but I have to say. So, okay. Now, the agreement states on page 1 that you're going to enter a plea of guilty, withdrawal or not guilty plea to the first count, which is a fifth degree felony, breaking the amendment. And it alleges that, or it states that you understand the maximum prison term for that is 12 months, minimum 6 months, fine bail of $25. You understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
Yes, sir.
Are you currently on probation, community control, parole, or post-release control for felony?
Yes, Your Honor.
Under the law, if you're convicted of this offense and sentenced to prison, you complete the prison term, it is possible the adult parole authority will place you in what's called post-release control for a period of up to 2 years. They don't have to if they can. If they do, you'll be supervised on the conditions they set. And during that period of time, they determine that you have not complied, they can return you to prison, making sure an additional period of up to half of your prison term for one or more violations. However, if you commit a felony or under post-release control, then an additional member sentenced judge in due case of imposed money. That judge also authorized the sentence, in this case, to an additional period of 1 year, whatever times that funding period of post-release control period, that occurs, that must be served separately, the sentence ends in this case. You understand that?
Yes, Your Honor.
I'm just looking at the discovery here. Mr. Kramer, according to the discovery, you were put on community control in Adams County in 2019 for aggravated possession and illegal conveyance. Are you off probation in that case?
Yes, sir.
Okay, all right. Now, under the law, I'm not required to sentence you to prison for this offense. I can't impose what's called community control or non-prison sanctions, which means that instead of going to prison, you put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. And during that period of time, the probation department felt that you were not compliant. They filed a written notice after the court, served a copy on you. You had a hearing and be entitled to have an attorney to represent you at that hearing. The outcome of the hearing was that you failed to comply, and at that time, the court could revoke community control, then sent you to prison for 12 months, fining you $2,500. You understand that?
Yes, Your Honor.
Right now, under the law, I'm not required to send, the charge in this case alleges that on or about November 7, 2021, Madison County, Ohio, Samuel McKee, Brian Lee Van Dusen Jr., you, and Selena Kinzer did knowingly by force, stealth, or deception, trespass in a non-occupied structure to wit, an empty house, 3853 State Route 136, Hillsborough, with purpose of committing therein a theft offense, as defined in ORC section 2913.0281 or felony, violation section 2911.13a of the Ohio Revised Code. So that's the charge of breaking and entering, 53 felony, with possible prison term from 6 to 12 months, fine $25. Now, Mr. Kramer, do you understand what it is you've been charged with, what the state said you did, when, where, and how they let you did it?
Yes, Your Honor.
And have you discussed the nature of the case, the evidence of the case, possible legal issues of the case, possible offense, might try to raise the trial, possible outcomes of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with your advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any type of drugs or alcohol at this time?
Yes, Your Honor.
Are you taking any prescription drugs?
Yes, Your Honor.
Are you, what are they for?
I think some rule of high blood pressure, suicide, diabetes, and ibuprofen for rock and
Okay. Nothing of those cause you to have any problem understanding what's going on or comprehend what you're reading or tell the court your response is appropriate.
I understand.
Okay. Now, And then expression may think plead guilty here today. Now, toward the lower fourth of the page 2 of your agreement, there's several lines printed in bold and underlined, and one sentence is marked out. So, meaning it doesn't apply, so I'll read those sentences to apply. Defendant shall under plea of guilty to count 1, state dismiss count 2, state defense will argue sentencing, defendant shall cooperate fully in prosecution of the defense. That's your understanding of the agreement? Does anyone promise anything other than case you plead guilty here today? Right? You've not been promised any specific sentence if you plead guilty here today. Right now, do you hold any license or certification from any state governmental agency that regulates any profession or occupation? Right now, you have rights you must understand before and accept the plea. First, you have right to counsel, this was appointed to represent you. Now, that wasn't simply work the case out, but to provide any defense that could be available to you other involved you wish to provide. So, if you decide you don't want to plead guilty, should continue to defend you and represent you, believe in triumph, that's what you want. You understand that? Right now, under the law, in this case, Mr. Kramer, you have a right to have a jury trial in which 12 people will be selected group of citizens that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented, and then they will be instructed on the law, and that jury will have to decide by unanimous verdict between all 12 of them, after agreed on whether the state proved your guilt of this charge beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive, which means give up and write to have a jury trial. In that case, you have to hold a court bench trial, meaning the judge will be the one to hear the evidence instead of the jury. The judge will apply the law, and the judge will decide whether or not the state proved your guilt or proved beyond reasonable doubt. You understand that? Right, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney over court. What that means is that the witness against you have to come in court and testify in front of you, your attorney, and anyone else present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence and help your side of the case. You understand that? Now, in the Constitution, you have the right to use the power of court, compel court witnesses to be in court to testify for you to save the state. So, if you have witnesses you're uncertain of what you've been voluntarily, you request court issue court order, less a subpoena, and force those witnesses to come to court and be able to testify if you want them to. Even though they don't want to be here, the same way the state witnesses are required to come to court. You understand that? All right, now, under the Constitution, you're presumed we have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time including the trial. I will never make you testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way or any person at any time. No one's even allowed to talk about it except in one situation, which is if there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that? Right now, under the Constitution of Kramer, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof is on you to try to prove you're not guilty simply because you've been accused of fact under the law. You don't have to put on any defense in trial at all. Okay, it's not required to, whether you do or not. Burden will remain on the state of Ohio to prove your guilt on every essential element of the offense charge. Or prove beyond reasonable doubt. It's the highest burden of proof is known under the law. You understand that? Now, originally you entered plea not guilty. The not guilty plea denied the allegation, denied committed a crime, and exercised and revoked all the rights that was described. If you change your plea from not guilty to guilty, that is the plea opposite not guilty to guilty plea within the allegation to the indictment of their crime. If you committed a crime, that plea, waive, give up all of the rights that was described for you today, except your right to have an attorney, which is all you have no matter what you plea. But that except your plea of guilty, waive, give up your right to your court trial, waive, give up the right to confidence against you, cross-examine for your attorney. Waive, give up the right to use the power of court. Well, of course, that's on your behalf and same mistake. You waive, give up, or approve of self-incrimination because we say you're guilty, that's what she's defined for. And a waive, give up, or innocent because we say you're guilty, the state's not required to prove you're guilty. It also says then subjection being sentenced immediately by the court. And finally, a waive, gives up, and right to file appeal, which you think you may have at this point in the case. Now, if I should sentence you to the maximum sentence, certain circumstances, may be able to file an appeal. And after you file within 30 days, your sentencing is to be filed. You understand all that? And are you a U.S. citizen? All right, Mr. Kramer, do you have any questions about the charge or possible penalties? You understand it? Do you have any questions about the plea agreement? Understand it? Do you have any questions about the constitutional rights that were claimed to you? You understand those? Do you have any questions about plea guilty, what it means, what will happen to him out here today? All right, is there anything else you would like to speak to your attorney about before we go any further? Okay, and you have any questions about anything? All right, and as to the charge in the indictment count 1, which reads that on or about November 7, 2021 in Highland County, Ohio, that Samuel McKee, Brian Lee Van Duz Jr., you of Selena and Pinter did knowingly by force, stealth, or deception, trespass in unoccupied structures within the house of 3853 State Drive 136 Hillsborough, purpose to commit in a theft of man's as defined in ORC section 2913.021, or a felony, a 53 felony, breaking in a bond for the term of 6 to 12 months, and a fine of $25 value. Alright, the court finds that this day on the court defendant was advised of all his constitutional rights by a no intelligent voluntary waiver of the same percent from Rule 11. Please accept the court file, defendant found guilty of the offense. The court will present investigation and will set the matter for sentencing on May 18 at 9 a.m. Opposition. All right, any further questions? All right.
Mayor, could you also, sorry, Mayor, could you also order a drug court assessment for Mr. Kramer?
Well, if he wishes to apply, yes, you can contact Ms. Sturgill and meet her.
Okay, thank you.
All right, thanks. Okay, I believe that's everybody then. So Mr. McCain's over here, come on over, Mr. Hangman, this ready. And we have a 10 o'clock hearing for Star then. Mr. Haynes, you can go ahead and leave your computer on. I'll just leave here. And we'll let this be recorded. Oh, that's a video.
Yep.
From MACI. You have to do a indictment.
Yeah, it should.
These under financial split.
Okay. What do you need? Go ahead.
bring lady to this office, and she can just get back there ASAP. You are Nicholas R. Kennedy.
Yes, sir.
I'm Fred Turner.
All right. And we also have a new indictment from Kennedy, and whether or not he's going to point to CR 74, and it looks like he was. Been served for this one?
No, not yet.
Oh, okay, sir.
Oh. Okay.
Finally, April 5th, some position that's why I didn't serve. Alright. So you want to go ahead and go forward with the plea on this other case without the investigation going away?
We will go forward with the plea and then, I'll waive service, the reading of the indictment on the line.
Alright. We'll need to get it served then.
Okay.
Get it served with it, right? I've got 10 o'clock, I've got to take with the institution. So let's go ahead and just take a break, get it served, and I'll get this video on here, and then, because I had so much trouble getting that on, I'll take a chance at this. That is,
Mr. Jordan?
William Jordan, pre-trial. And go ahead and fill out that paper there for Mr. Douglas. It's just
Yes, sir. It's Mr. Reno here, Common Pleas Court. I have a gentleman that needs to be served tonight.
okay, he's there. He's Danny. Oh, he's entering by Zoom. All right, that way. Can you hear me, sir?
Yeah.
All right, you're Mr. Gordon?
Yeah.
Okay. All right, Mr. Kirk, Mr. George is appearing by video from the institution on Zoom. So this is case number 22 CR 51, State of Ohio versus William S. Jordan. Mr. Jordan is appearing by video from the institution. His attorney is appearing by Zoom. He has another hearing, I believe, by Zoom also here shortly. The defendant is charged with burglary, grand theft, firearm, grand theft, and break and entry. Good knows that the assistant prosecutor came to present in the courtroom, and the defendant was indicted back on March the 1st. This is the first pretrial. We have a final pretrial set on May 18th, and trial date on June 13th. I see the state provided discovery and the bill of particulars. You've got both of those, Mr. Kirk. Did you receive both of those, Mr. Kirk? Oh, okay, I am. Okay. Yeah, Mr. Kirk, Mr. Jordan is here from the institution, and Mr. King is present in the courtroom. And did you receive the discovery and the bill of particulars that was filed?
I believe so.
They were filed in the court for April.
Yes, I did.
Okay, and are you anticipating any pre-trial motions?
And not this time.
All right. And did you receive a written plea offer yet?
I did.
Has that been communicated yet to the defendant?
Yeah, I got it.
Okay. All right, well, I'll have him return for the May 18th retrial in person rather than trying to do it by video. And you can discuss that with him at that time.
Okay, thank you.
All right, are there any other matters then that need to be discussed at this time?
There
All right, then Mr. Jordan, you'll be brought back here on May 18th for your pre-trial. Let's see, where is it? Where are you located?
Madison, correct?
Madison? Okay. So they'll get you that morning and bring you down here and then have that here that day. All right, thank you. All right, see, Ms. Powell's on the screen from the jail. We'll go ahead and do that. Mr. King is present in the courtroom. Mr. Kirk is her attorney. He's very much in his office. You're Alyssa Powell, attorney from the jail. All right, Ms. Powell was placed on police patrol on August 11th, 2020 on, I believe, the charge of forgery, a second-degree felony. The probation department filed a notification that she allegedly violated internal community control on April 11th, alleging that she had violated Rule 2, failing to report since August 2nd of last year. Rule 15, Post 57675, and court costs and medical payments. And Rule 19, is to complete recommended aftercare, or recommended treatment as court. Now, the court notified Ms. Powell of those allegations, appointed Mr. Kirk to represent her. Mr. Kirk, have you had an opportunity to review these allegations with your client? And is she, will she have a hearing, or is she going to be admitted?
I did explain the rights of the hearing first, she does wish to make that right and it is a violation.
All right, Ms. Powell, you understand the allegations against you? And under the law, if you admit these violations, or if you're found to have violated after hearing, one of three things can happen. I can continue to community control with the same conditions that were ordered originally. I can continue with additional conditions I think are appropriate. Third, most serious, I can revoke your community control, sentence you to prison in 6 to 12 months, and fine you $2,500. You understand that? Does anyone promise you anything, threaten you in any way to get you to make these conditions? You understand the consequences if you admit. And you admit to those allegations that I just read to you? Alright? Anything from the state or probation regarding this position, Mr. King?
Yes, Your Honor, thank you. Given that this is the defendant's first violation, this is based on community control. The state would ask that she be continued on community control in order to complete the STAR program. There is a bed available at STAR on April 28th.
All right, Mr. Kirk, I've heard that an officer to start that available on April 28th. Anything that you'd like to say, Kirk?
Thank you, Your Honor. We would ask the court to continue moving until the start. My client is also violated some of the reasons in Claremont County, and they also recommended STAR. I think that's how the STAR did it come about. So I have spoken with her about how she does believe the STAR did fit her. She suffered from a relapse, there were no excuses to be about it, and luckily no felonies or criminal charges here. Just what we would see with a relapse family with potential in the average care. So we would ask the court to continue moving towards the STAR.
Pounds, anything you'd like to say? All right, well, it's the order of the court then that the community control be continued with additional conditions that you complete the STAR program and aftercare. You'll remain in jail until you pay the STAR on April 28th. Now, you need to understand this, Kyle, is your last chance, and if you don't complete STAR, court will send you to prison. You'll get kicked out because you didn't want to do the program, or you didn't apply, or just refused to apply. Come back here, there won't be any further extensions of community control or probation, you understand? All right, thank you. All right, I believe that police officer. All right, we're ready for Mr. Kinsey. Well, thank you, sir, and restore. All right. Adam, are you or anything licensed in federal court?
No, but Jim is.
Oh, Jim is?
Yes.
Just wait on that. Factual.
The indictment.
Oh, okay.
I'm trying to get back to the.
Well, let's go ahead and do this plea, and then you can check it out.
Okay.
Okay, case number 22-061, and State of Ohio, which is our record. In this case, Mr. Mackenzie started with trafficking and heroin, aggravated possession of a fentanyl related compound. So this is pre-trial, and the court has been provided a plea for Mr. Mackenzie, which indicates when you wrote down the plea guilty to count one. This 3-page form of doctor's office prepared on page 3. The signature line of the sentence reads, I entered this plea voluntarily, and we look below that for almost like initials of this Mackenzie, that's your signature.
Yes, sir.
When did you sign this document?
Just now.
And did you go to the attorney before you signed it?
Yes, sir.
Did you understand that this agreement to plead guilty with we won't be trial next case to be sentenced in hearing?
Yes.
Is this something that you and Shane talked about before it came here today?
Yes, sir.
So you're not surprised by this development?
No.
Right? And you've had enough time to fully consider the matter before signing this agreement?
Yes, sir.
Are you entering into this agreement voluntarily? Now, states that you're going to plead guilty to count one, trafficking and heroin number 25.0381, Ohio Vice Code 53 felony. Further states you understand the maximum penalty for that prison term imposed would be 12 months, minimum 56. There's a fine available up to $25 off the license suspension 6 months to 5 years. Do you understand that?
Yes, sir.
Are you facing, if you are facing this other felony charge, I forgot some single count, I think,
53 felony possession.
So, any event that you should be convicted in both this case and that case, and if you should be sentenced to prison in each case, then those sentences could be ordered to be served consecutively, meaning one after the other. You understand that?
Yes, sir.
Other than these 2 charges in this court, are you facing any felony charges anywhere else?
No.
Are you currently on probation, due control, parole, or police control for a felony?
Yeah, here.
Other than this.
Oh, no.
Right now, under the law, Mr. McKenzie, if you're convicted and sentenced to prison, part of the law provides that on completion of a prison term, the adult parole board may, at their option, put you under close release control supervision for a period of up to 2 years, meaning you'll be supervised by a parole officer in terms they set because of course not involved in that. If they determine that you have failed to comply, they can return you to prison until you serve the entire term set by the court, or an additional period of up to, in this case, half your prison term for one more violation. But if you commit a felony, well, under close release control supervision, then in addition to sentence the judge in the case for code 20, the judge would also order you to serve an additional sentence of 1 year or whatever time is left on that close release control, permitting that if that's under close release control in this case. And if that occurs, that sentence that will serve consecutively the sentence in the case. You understand that?
Yes, sir.
Right now, the law does not require that you be sentenced to prison for this offense. You can receive what is called community control or probation, and that means that instead of going to prison, you would be put under supervision probation officer for a period of up to 5 years in the term set by the court. And if during that period of time, probation department felt too long, they would file written notice up to the court, sort of copy on you, and a hearing would be held, and you would have a hearing, turn. And in the event that the outcome of that was you failed to comply, at that time, the court would terminate you from control and sentence you to prison for 12 months, fine, $25. You understand that?
Yes, sir.
Right now, the charge in this case alleges count one that on or about September 17, 2020 in this county, you did not only sell rock, but sell heroin, Schedule 1 controlled substance in violation of 9.5. So that's the charge we're talking about, the 5th degree felony. Now you understand what it is you would charge with what the state said you did when or how they did it.
Yes, sir.
You understand the common penalty.
Yes.
you discussed the nature of that charge, the evidence of the case, possible legal issues of the case, possible defense might try to raise a trial, possible outcomes of the trial with your attorney.
Yes, sir.
Are you satisfied with your advice and comments in this matter?
Yes.
Are you, under the influence of any type of drug, alcohol, this time?
No, sir.
Have any threats made to you plead guilty here today?
No, sir.
Now, on page 2 or little 3 plus line printed bold underline reads as follows. Defense lawyer pleaded guilty to count 1, state will dismiss count 2, state defense joint director including control of residential substance abuse treatment. Then agrees to repay by money, United County tax board for amount of $60.
Yes.
Is your understanding of the agreement?
Yes.
You don't promise anything other than that case you plead guilty?
No, sir.
Under the law, if you plead guilty to this charge, of course, not bound by the sentencing recommendation of the parties. So I could follow the recommendation or might decide that's not the correct sentence under the law. The evidence that the court could sentence you to prison for 6 to 12 months, fine you $25, and suspend your license for 6 months prior. You understand that?
Yes, sir.
All right? Now, do you hold any license or certificate from any state agency, governmental entity that regulates any trade or occupation? Well, like a license, like a pharmacy tag or barber or something like that?
No, sir.
Okay. Right now, you have certain constitutional rights and understandings from the Kansas court, except this plea. First, you have the right to have an attorney and this representation. Not simply work the case out, but provide any defense might be available to you under the law to assure body. So, if you decide that you don't want to do this, to continue to represent you, including a trial, that's what you decide you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this case, which 12 people be selected from a group of citizens who live in this county and subject to jury duty in the trial. After they're selected, the evidence will be presented, they be instructed on the law, and they will decide by unanimous verdict, meaning all 12 have agreed as to whether the state jury would go. If you didn't want to have jury trials, you didn't want to plead guilty, way the right to give up the right to have a jury trial. In that case, you would ask for a bench trial. That means instead of the jury hearing the evidence, the judge will hear the evidence, the judge will apply the law, the judge will decide whether or not the state jury would go, who would go. You understand that?
Yes.
Under the Constitution, you have a right to confront witnesses against you, cross-examine, and open court for your attorney. What that means is the witnesses against you have to come in court and testify in front of you, your attorney, and anyone else present. After the prosecutor is done asking questions, your attorney asks questions, it's called cross-examination. And the purpose of that is to try to bring out evidence and help your side of the case. You understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, just like the state. So, if you have witnesses you're uncertain whether voluntarily, the court, on your request, will issue a court or subpoena and force those witnesses to come to court to be able to testify even though they don't want to be here, which is the same way the state's witnesses are required. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way, by any person, any time in the proceedings. In fact, no one's even allowed to comment about it except in one situation. If there's a jury trial, and you don't testify, the judge instructs you for that process, your right, they cannot consider it for a person. You understand that?
Yes.
And under the Constitution, when you enter a plea not guilty, you deny the allegations in the indictment, deny committed a crime, and you revoke or exercise all the rights that I just described. If you change your plea to count 1, not guilty, that is the opposite of not guilty. It admits the allegations in the indictment in their crime, and that you committed that crime. That plea waives, gives up all the rights that I just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. So without exception, your plea of guilty will waive, give up your right to have a jury or court trial, waive, give up the right to confront witnesses and issue the cross-examination for your attorney, waive, give up the right to use the power of court, compel or force witnesses to be in court, testify for you the same as the state. It will waive, give up your privilege against self-incrimination, because you're saying you're guilty, doesn't receive fines for guilty. A way to give up your presumption of innocence, because the state you're guilty, the state doesn't require proof. It also subjects you to being sentenced to being indicted in court, and finally, it gives up any right about the plea. You didn't pay that until this point in the case. Now, if I sent you back and sent under the search circumstances, you probably that would have to be filed 30 days for sentencing it. You understand all that?
Yes, sir.
Are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge or possible penalty?
Yes.
You understand?
Yeah.
Have any questions about the plea agreement?
No.
You understand it?
Yeah.
Any questions about the constitutional rights of the complaint?
No, sir.
You understand that? Have any questions about the plea guilty, what it means, what the consequences of that would be if you enter here today?
No.
You understand?
Yeah.
Is there anything you'd like to speak to Ms. Wood about?